We got a whole issue. All my constitutional rights have been violated. I want it on the record.
Before the chaos even settles, this case opens with the defendant already on the offensive, claiming constitutional violations before the court has even established basic procedure. That alone sets the tone. This is not going to be a calm, structured hearing. What you're about to witness is a courtroom collision between authority and defiance, where procedure clashes head-on with emotion. Now here's the key. In any courtroom, especially under a judge like Judge Simpson, structure matters more than anything. You don't just walk in and start making claims, you follow process. And right away, the judge shuts that down. Why? Because from a legal standpoint, if a defendant starts rambling, as the judge puts it, it disrupts the record and undermines the court's ability to proceed efficiently. After the dialogue, notice how quickly control shifts. The judge asserts dominance by demanding in-person presence. That's not just preference, it's authority. Courts require physical presence for accountability, especially in serious matters. Already, you can see the dynamic forming. The defendant wants to control the narrative, but the judge is focused on controlling the courtroom. And that tension, that's what's going to drive everything that follows.
I was arrested by a lie. I want it on
Okay,
the
first of all, I'm
on
going to
the record.
stop this. I directed this defendant to be in this courthouse in
I got a
person.
bad back, sir.
And he is
I
not
got-
here in person.
Sir, I got
I
a
am
bad
not going to
back.
sit here
I
and
got a
listen to
medical
him
issue.
ramble on and on about everything.
Oh, really?
If you're
You
going to
gonna
say it
violate my
all, you're going to
constitutional
say it to my face. Court does call the case of the people versus Dwight Miller.
Michael Gaddy's, assistant public defender on behalf of Mr. Miller, who's approaching, Judge.
Your name, sir?
Said Dwight Miller.
Okay.
Oh, yeah,
My
yeah.
back hurt.
You're looking to adjourn this?
Yes, Your Honor. I have received the discovery. I've given Mr. Miller a copy. We need to meet and go over it thoroughly.
October 30th,
That's fine, Judge.
2025, 9 a.m. Bond. Thank you.
Oh, yes, Your Honor. If I could address one issue. Mr. Miller has indicated that his phone was seized at the time of arrest. It didn't look like any of these charges stem from any cell phone. I don't know if the court would consider granting that an oral motion to return the phone, or will the court need a written motion for that?
This is where things start getting legally interesting. The defense raises an issue about the seized phone, something that, on the surface, sounds simple. Give it back. But legally, it's not that straightforward. Once an item is seized during an arrest, it can be held as evidence, even if it's not immediately clear how it ties into the charges. The judge's response is actually textbook. He refuses to rule in the dark. That's critical. Judges cannot make decisions without verified information, especially when it involves potential evidence. If that phone contains anything relevant, even indirectly, it could impact the entire case. Now watch the defendant's reaction. Instead of letting his attorney handle it strategically, he jumps in emotionally, talking about bills and personal inconvenience. And here's the problem. While that's relatable, it doesn't carry legal weight in that moment. Courts operate on evidence and procedure, not personal frustration. This creates a disconnect. The judge is speaking legal logic. The defendant is speaking personal urgency. And when those two don't align, it often escalates tension, which is exactly what's happening here.
Mr. Gaddy brought this up to me for the first time this morning, and I said I needed to check with the police. I don't have any information about that off the top of my head. And
Yeah, I don't.
any cases today, no one popped up yet, so I just asked for some time to see if it's been seized as evidence or what's going on with it.
Your Honor, I want to put it on the record. My phone had nothing to do with it.
Okay, I would advise you not to say anything.
I can't, I won't order something in the dark, so I don't know why.
I can't
If
pay
you
my
say-
bills. I can't pay my bills. All my cards is hooked up.
Okay, so what do you want me to do? Because if you're gonna listen to me, you listen to me. I'm telling you why I can't do anything right now, because I don't know why they took it. I have no idea. I don't know if counsel knows. Certainly the prosecutor doesn't know, so I don't know.
They brought the charges. They pay my bill.
What you're stating is illogical. I'm not even gonna respond to that.
CNA District Court for County Washington, I'll say if this is not suggested, y'all.
Maybe see
Downstairs. They did
them
not.
downstairs.
Yeah.
Okay, got it. Court does call the case, people versus Dwight Miller.
Ashley Feltus for the people.
Michael Gaddy, assistant public defender on behalf of Mr. Miller, Your Honor.
He's still muted.
I believe he is orange pants, white shirt, Judge.
I got
Oh,
it.
I was just happy I could read it.
Thank you for pointing that out. I figured out where he was. Oh, there he is. Mr. Miller, can you state your name, please?
He may be muted, Judge.
No, he's not muted.
Oh.
Sir, can you state your name?
On and for the record. My name is Dwight Miller. I'm American State National. I'm here to challenge jurisdiction. I'm here on special appearance to establish jurisdiction, bro.
Now, this is a major turning point, and if you've seen similar courtroom cases online, you'll recognize this pattern immediately. The defendant is attempting to challenge jurisdiction using what's often associated with sovereign citizen arguments. Here's the reality. Courts have consistently rejected these claims. Saying you're an American state national or demanding proof of a judge's delegation of power does not invalidate jurisdiction. Judges derive authority from election or appointment under established law, not from documents they need to present on demand in court. Judge Simpson handles this carefully but firmly. He answers the question once, explaining his authority comes from the people, but then immediately advises the defendant to stop. That's not intimidation, that's guidance. Because continuing down this line can actually harm the defendant's position. And here's the bigger issue. Instead of focusing on the actual charges, the defendant is diverting energy into arguments that courts simply don't recognize. That's a strategic mistake, because while he's trying to challenge the system is continuing to move forward without him gaining any ground.
Can we approach, Your Honor?
Your Honor, I need to challenge jurisdiction.
Okay, how are you intending on doing that?
Well, Your Honor, can you show me your how I'm supposed to do this? See, it's certain things I can't remember because y'all got me in here and I don't have access to the law books. But it's okay.
Your Honor,
There are certain things you want me to show
your
you?
delegation of power, sir?
Pardon?
Can you show me your delegation of power and your oath of
My
office?
delegation of power
Yeah,
came from the people of Washington County that elected me. I have a certification of election in back. You want it?
Mr. Miller, as your
I would like
attorney,
a copy of your surety bond, please, and your oath of office.
My surety bond. I don't
Yes.
have one. I'm insured by the county.
So you don't have one?
And state.
Okay. You don't have a surety bond, huh? So what's your
Mr. Miller, I'd advise not to
swear oath to the Constitution, right? Yes or no?
I'd advise you not to continue this line.
Man, I'm in here. I done got victimized this morning. Are you serious? Can I get a breakout room with my attorney or my so-called attorney?
So-called attorney? No, he's a very good attorney, and he's not a so-called attorney, and you'll not refer to him that way because as you won't be disrespected, neither will he.
This moment is subtle, but extremely important. The defendant calls his own attorney a so-called attorney, and the judge immediately shuts that down. Why? Because respect in the courtroom isn't optional, it's foundational. From a legal standpoint, undermining your own counsel is one of the worst moves you can make. Your attorney is your voice in the system. If you discredit them, you weaken your own defense. And the judge recognizes that instantly. But there's also a deeper layer here. The defendant is showing clear distrust, not just of his lawyer, but of the entire process. That kind of mindset often leads to impulsive decisions, like speaking out of turn or rejecting legal advice. And we're already seeing that pattern unfold. The judge, on the other hand, is maintaining structure. He's reinforcing boundaries, keeping the process intact, and ensuring that the courtroom doesn't spiral into chaos. This is where you start to see the contrast clearly. One side operating on emotion and distrust, the other on procedure and control.
Okay, may I speak with the attorney in a breakout
You can
room?
do that on your own time. He doesn't get a breakout room here because he's live in the courtroom.
Okay. So
what are we doing with his case now that my jurisdiction has been established?
okay, I'm putting the motion in for dismissal because ain't no so-called witness or victim.
And not end this? Yeah. Oh. First, yes, you may.
So how's y'all having a conversation without me being there?
Okay. Back to the record in the Dwight Miller case. what I'm gonna do, until you're requesting an adjournment in this matter.
I am, Your Honor. Upon information, believe there may be a new case coming. I understand Mr. Miller booked into the
Your
jail
Honor.
at 10 o'clock this morning.
Your Honor,
So I'm asking one
I
week to
object.
evaluate.
I object. I object anything she talking about. First and foremost, how was you testifying?
Yeah, what?
First and foremost, Your Honor, I want this charge dismissed, man. At no time given, the lady
I
lied.
know, I heard your motion to dismiss.
Okay,
I denied
listen.
it already.
Listen, Your Honor, under the Constitution, what is it exactly? The maximums of law. If something comes from a falsehood, what is that? The first words out this woman's mouth, she lied. She made a story
You're
up
not-
talking about somebody
Okay,
put
this
a weapon at her.
woman is
Nobody
an
pulled no
assistant
weapon at her because
prosecutor.
nobody
first
had
of
no
all.
weapon.
I believe he's speaking of the complaining witness, but
Oh, the complaining witness. Oh,
But you-
not Ms.
but
Felton?
Mr. Miller, I would advise you not to say anything more. Given the circumstances, it may be prudent to discuss this matter further and to see there's a couple other things pending, as well as a potential new charge they're indicating. This might be something we want to set
No.
over for a week.
No. I'm not worried about no new lies. Look at me. I got beat up this morning, bro. I called Pittsfield police 13 times. I was getting assaulted with motherfucking tasers and shit.
Okay,
Now the emotional intensity spikes again. The defendant is making serious claims: assault, being tased, calling police multiple times. These are not minor allegations. If true, they could have major implications. But here's the issue: timing and method. Courtrooms are not the place for unverified emotional outbursts. There are legal channels to file complaints, present evidence, and pursue those claims properly. The judge's response is pragmatic. He acknowledges the situation but redirects the focus. Why? Because the court cannot resolve those allegations on the spot without investigation. Instead, he adjourns the case, essentially buying time for facts to be clarified. This is actually a strategic move. By expediting the timeline to just 1 week, the judge is signaling urgency while still maintaining order. Yeah, now think about this. Do you believe the defendant's claims strengthen his case, or hurt it by how they're presented? Because in court, how you say something can matter just as much as what you say.
I put it on the record. Then all of a sudden they want to switch it up to make it seem like I'm threatening somebody. I ain't threatening no one.
okay, but we can't resolve
I
all
never
that today.
threatened no one. The same people
I
that's
know.
making these
Okay.
statements, they all three on felony probation. They done got caught.
Okay.
Their house just
Okay,
got
so we
raided.
can't resolve
And then they up
that
here
today.
playing line up on me.
Okay, so look, we can't resolve that today. And I think the best thing to, so that everybody can try to figure out what's going on, is I'm going to adjourn it out a week. Rather than 2 weeks. I'll try to expedite it. Let's see if we can get to the bottom of it all. So,
Your Honor,
probable cause conference.
Your Honor,
Probable cause conference will be adjourned to November 6th, 2025, 9 a.m. Bond will continue.
And I should correct my statement, Your Honor, that mag thing we saw, we discussed at the event, I think it's just the court it's going to. I don't know that it's revolving the court. Thank you.
Thank you.
so I just got railroaded, huh?
No, that's not railroaded.
Yeah,
I'll let you know when
because
that
I'm not consenting to none of this. The lady,
Yeah, cut him. I'm done. I'm so done. Is he gone? I feel a cold coming on for this sale. It's like a hairball. I don't know. Court calls case People versus Dwight Miller.
Mr. Miller, it's my understanding Mr. Miller is, Mr. Miller, I don't know what you're showing us, but what, would you state your name for the record?
American State National. All my rights have been violated. They can't.
Did you
produce a
state your
weapon.
name first?
American State National, man. Oh, Your Honor, I've been asking for the whole time, man. There ain't no firearm. There never was a firearm. I was kidnapped. My rights was violated. The lady lied on the scene. She said she called the police, said somebody pointed a firearm at her. Then when the police came on the scene, she made that statement again. And then it was proven, the cameras proved none of that happened.
If you want to try to overtalk me, you can. It's not going to work.
Here, the defendant shifts back to the core allegation, claiming there was no firearm and that video evidence supports him. Now this is where things could actually matter, if handled correctly. Evidence like surveillance footage can be powerful. If it truly contradicts the accusation, it could dismantle the prosecution's case. But again, the delivery is the problem. Instead of allowing his attorney to present this strategically, the defendant pushes it aggressively during a procedural hearing. The judge responds by reminding him, "This is not the time to litigate the case." That's crucial. At this stage, the court is dealing with scheduling, probable cause, and procedural steps, not determining guilt or innocence. By insisting on arguing the case prematurely, the defendant is essentially speaking at the wrong time in the process. And in law, timing is everything. The frustration is understandable, but the approach is counterproductive.
Dwight,
It's not the time for you to try to litigate your case.
Where's the
Dwight,
firearm?
Dwight, just listen. I was just appointed yesterday. Mr. Gaddy gave me the discovery this morning. Why don't we ask for a 2-week adjournment and you and I can talk?
Where's the firearm? Where's the so-called person that's the victim that signed the sworn
Any
affidavit?
objection from the people?
No, Your Honor.
Probable cause conference will be adjourned
I object.
to
I object. I
November
object.
20th.
I object. I object. I don't get
Objections
consent.
noted and denied.
You violate my
November 20th,
constitutional right.
2025,
I
9
ain't about to
a.m.
write you up. I'm about to sit up
Bond
in
will
judicial
continue.
review.
And you know what? So
I'm about
let's
to sit
do
in
it this
judicial
way.
review.
That hearing will be in person. So if you got
my
something to
back
say, you
messed
can
up.
come right here and say,
My
person.
back messed
Thank
up.
you.
know that.
Mute him.
You know my back messed up.
You're welcome. Court does call the case, People versus Dwight Miller.
People.
Good afternoon, Your Honor. Rob J. Kilowald calling outside of Judge Slay's courtroom. Good afternoon, Your Honor. Dwight, would you state your name for the record?
I'm American State National. I'm appearing sui juris. You is not my attorney. That's not working for me. We got a whole issue. All my constitutional rights have been violated. I want it on the record. I was arrested by a lie. I want it on the
Okay,
record.
first of all, I'm
On
going to
the record.
stop this. I directed this defendant to be in this courthouse in
I got a
person.
bad back, sir.
And he is
I
not
got-
here in person.
Sir, I
I am
a
not
bad
going to
back.
sit here
I
and
got a
listen to
medical
him
issue.
ramble on and on about everything.
Oh, really?
I don't
So you
mind
gonna
hearing
violate
from
my
people, but I
constitutional
tell
rights?
you, if you're
You
going
gonna
to say
violate
it
my
all, you're going
constitutional
to say it to my face. Bench
You gonna
warrant will
violate
issue
my
for defendant's
constitutional
failure
rights?
to appear. No
I
bond.
am here.
We'll get him
I can't-
here.
I got a
Thank
medical
you.
issue.
You
So you
can
gonna
mute
violate
him.
my
Thank you,
constitution-
Mr. Kilowald.
Okay, Judge. Thank you. Judge, if I may say, he does have some medical issues. That being said, all I wanted to do was set it for exam.
Well, when he gets here and graces our doorstep, I'll be more than happy to set it.
All right, I'll bring my constitutional book. Thank you, Your Honor. Thank you.
All right, thank you, Mr.
Bye.
Kilowald. Court does call the case, People versus Gary Coward.
Good afternoon, Your Honor.
Hey, Simpson, I'm coming to see you, bro. You violated my constitutional right. I am coming to see you, bro.
Hey, I hope you are not making a threat against me, because that's going to cause you a whole bunch of other problems. Get that number. Yeah, I bet you it did log out. Get that number. It will have the full number. We'll go find him. Get the detective bureau on that, please. All right, let's go. You don't want to come up here now, do you? I know. He's just standing there like, man, I just, oh, my name, I'm just up
Do you
here.
want me to contact Detective Bureau for you?
Pardon?
Do we reach out to the DB?
I think he is.
Okay. Yeah.
Your name, sir?
Gary Coward.
And who's representing Mr. Coward? Mr. Burgess?
I am. Sorry, Your Honor. Good morning. Good afternoon. May it please the Honorable Court, David Burgess on behalf of Gary Coward. I'm appearing via Zoom, Judge, because it seems a little scary in your courtroom today. So.
Wow. I'm calm.
My client is present, Your Honor. He's raising no constitutional issues, and he is a citizen of the United States.
Thank you.
I'm done, Your Honor. Sorry.
No, you're not. You are just getting started. What are we doing on this case?
And this is where everything crosses a line. What started as frustration now escalates into what could be interpreted as a direct threat toward the judge. And in a courtroom setting, that's extremely serious. Judge Simpson reacts immediately, because he has to. Any perceived threat against the court can lead to additional charges, including contempt or even criminal threats. This is no longer just about the original case. It's about behavior in court. Looking at the full picture, this case is a clear example of how courtroom conduct can shape outcomes. The defendant may believe his rights were violated, but the way he presents himself is undermining his position at every step. Interruptions, disrespect, and emotional outbursts are not just ignored. They actively work against him. Meanwhile, the judge maintains procedural control. Ak ensures the case moves forward and responds decisively when boundaries are crossed. The takeaway is simple. In court, strategy beats emotion every time. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.